Good morning, ladies and gentlemen. I'd like to call this meeting of the Advocacy Committee to order at 11:08 a.m. Thank you for joining us this morning. In keeping with our longstanding position that public dollars should stay in public schools, I am presenting to the committee for consideration two proposed resolutions. These were posted on board docs and sent to each of you by email last Friday. Because this meeting is being recorded, I will briefly walk you through each proposed resolution for our friends out there who may be listening before asking for a maker of a motion to put each resolution on the floor. Then I will ask the administration for comment and open the floor for questions, clarifications, or any proposed amendments to the resolutions. By way of background, during our June budget meeting, we discussed that our district anticipates severe revenue shortfalls in the next few years due to the shutdown of our economy last March, as a result of job loss, declining incomes and car purchases, and the closing of businesses in the county. As you know, the district's primary sources of operational expenses for school operations are income tax, sales tax, and property taxes on businesses and non-owner occupied homes. We receive no property taxes from owner-occupied homes for school operations. These revenue shortfalls will occur at a time when our operational expenses are increasing as a result of responding to this pandemic. Last March, Congress passed a sweeping law to help schools reopen safely. The funding is intended to assist with the significant efforts the district has taken to provide support for students. Against this backdrop, there are two measures being proposed at the state and federal levels which seek to divert much-needed CARES Act funding to private school children in South Carolina. Both measures are currently being fiercely litigated in court. The first resolution concerns the funding formula used to allocate CARES Act relief funding. To refresh your recollection, Congress passed the Coronavirus Aid, Relief, and Economic Security Act on March 27th of 2020, which the president signed into law. The plain language of the act directs that the State Department of Education, to allocate CARES Act funding in accordance with Section 18005 of the CARES Act, which clearly and unambiguously directs the U.S. State Department of Education to allocate funding to private schools in the same manner as provided under Section 1117 of the Elementary and Secondary Education Act of 1965. This is known as the poverty-based formula. The Elementary and Secondary Education Act, also known as ESSA, was an essential component. Sorry about that. Title I in ESSA is an essential component of President Johnson's War on Poverty, is a statute by which Congress provides federal funding for primary and secondary education. Title I of ESSA created a grant program specifically designed to improve the academic performance of disadvantaged and low-income children. On April 30th, 2020, the U.S. Department of Education issued guidance directing districts to provide private schools with CARES Act funding according to a percentage based on the total number of children enrolled in private schools, regardless of income level. This has come to be known as the enrollment-based formula. On May 5th, 2020, the executive director of the Council of Chief State School Officers published a letter to the Secretary of Education criticizing the department's guidance for attempting to funnel an inequitable amount of funding under the CARES Act to private schools. On July 1st, 2020, despite numerous objections, the Department of Education issued a final interim rule requiring districts to use the enrollment-based formula rather than the poverty-based formula unless districts agreed to limit CARES Act funding to Title I schools in the district actually receiving Title I funding. This alleged choice has the effect of increasing the proportion of CARES Act funding going to private school students at the expense of our most vulnerable public school students. As you know, many public schools serve significant populations of low-income students but are not designated as Title I schools. All of these schools and their students will be excluded from the CARES Act programs under the U.S. Department of Education's final interim rule funding formula. In Greenville County, 75.6% of students in poverty attend non-Title I schools and therefore would not receive the benefit of CARES Act funding if the interim final rule is used to allocate CARES Act funding. The proposed board resolution would urge our State Department of Education to allocate CARES Act funding in accordance with the rule of law, which clearly and unambiguously directs that the funding be allocated in the same manner as provided under Section 1117 of the Elementary and Secondary Education Act to students and teachers in non-public schools. Do I have a maker?
Madam Chairman, I'll make the motion to approve the resolution.
I'll second the motion, Madam Chairman.
I have a motion and a second. Thank you, gentlemen. Dr. Royster, would the administration like to comment on the resolution?
No comment beyond we appreciate the board's action in supporting what we believe is the intent of Congress in this and to provide us with additional resources to help deal with the coronavirus impact. I think it's also important to note, as you do in there, that private schools had the opportunity to seek funding while termed through loan programs. Those were actually forgivable loan programs, a source that the school districts did not have the opportunity to access.
That's correct. Thank you, Dr. Royster. Is there any discussion? Are there any questions, comments, clarifications? Yes, Mr. Lewis.
I'm not on the committee, but just out of curiosity, what's the next step plan for these resolutions once the board approves them? Is this going to the State Department of Ed or to School Board Association? How can we help you get the word out?
It would be my recommendation that if it passes out of committee, that it be placed on the committee of the whole meeting for next week. If the board passes the resolution, I suggest that we put it on the Eye of Legislation page of the district website, forward to the State Department of Ed. I've already spoken to the South Carolina School Boards Association, and we would distribute it through that association to other districts interested in taking a position on the matter.
Thanks. And can I ask Mr. Saylor's question?
Yes.
South Carolina School Board Association, do they have a similar position on this issue, or are they waiting on us?
They have a similar position also when it comes to what I'm going to call the Orangeburg lawsuit, and that's probably not the right term. We are currently offering an amicus brief connected to that. They're not directly connected, but they are connected, if that answers your question.
Thank you. Thank you, Madam Chair.
Thank you, Mr. Lewis. What Mr. Saylors is referring to as the Orangeburg case is pending in the South Carolina Supreme Court. The title of the case is Adams versus McMaster and the South Carolina Department of Administration. There's a hearing scheduled in that case on September the 18th of this month, and both the South Carolina School Boards Association and Public Education Partners of Greenville County and other entities plan to file an amicus brief in that case. That case predominantly addresses the use of GEARS Act funding, which is the subject of the second resolution. If there are any other questions, I'm having trouble getting everybody on the same screen, so please make sure you're unmuted or raise your hand so that I can see you.
Madam Chair, I may have two questions quickly.
Yes, Mr. Chamley.
The first one is, and I may have dozed off while you said this, I apologize. Did you say you're going to send a copy of this to the governor as well?
I did not say that, and I'm sorry I wasn't more entertaining, Mr. Chamley. But I'm quite sure that he will see it.
Good.
if it goes to the Department of Ed.
I apologize for that. The other one is the same statement, and that is, and I don't know if you heard you say that you would be sending, or that we would be sending this to the other school districts around the state. Now that's a few of them, quite a few, but I didn't know if you had said that as well.
It will be made available. It'll be on our website, and we'll make sure that South Carolina School Boards Association has a copy of it.
Okay.
And we would be happy to distribute it if it passes out of the board.
Thank you.
Thank you, Mr. Chambly.
Madam Chairman, this is
Yes, Ms. Morrison-Fair.
Yes, I would like to know the financial impact in case we are not taken seriously, especially since the South Carolina School Boards Association agrees with this position. How will this affect Greenville County?
Greenville County is, and Dr. Royce, correct me if I'm wrong on this, but Greenville County is slated to receive $19.6 million, I believe, under the CARES Act funding. And if the enrollment formula, which is outlined in the final interim rule, is applied, private schools would get 1.7 million of that. Is that correct, Dr. Royster? You're on mute.
I believe those numbers are correct, but Stack, that correct? I don't have the numbers in front of me.
The total allocation was 19.3 million.
Okay.
And the private schools would get 1.64 of that.
Okay, thank you for that clarification, Ms. Stack. Is there anything else, Ms. Morrison-Fair?
Thank you.
Thank you. Any other questions?
Let's go ahead and vote.
Okay. Hearing none, all those in favor of the resolution, please vote by both saying aye and raising your hand so that we can get a record.
Aye.
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 All those opposed? And the motion passes unanimously. The second resolution is more straightforward and concerns the governor's Safe Grants program, which, if implemented, would divert 2/3 of the governor's Emergency Education Relief Fund, also known as the GEAR Fund, to private schools. By way of background, in the CARES Act, Congress appropriated $3 billion for the governor's Emergency Education Relief Fund, which is also known as the GEAR Fund, which directs the U.S. Department of Education to make GEAR funding available to the governor of each state based on the relative population of students in the state, and in particular, the relative populations of students from low-income schools. The Act further provides that GEAR funds may be used to provide emergency support through grants to local school districts that the State Department of Education deems to have been most significantly impacted by coronavirus. South Carolina was awarded a GEAR Fund grant of over $48 million by the U.S. Department of Education. After receiving this funding, the governor announced on July 20th, 2020, the creation of Safe Access to Education Grants Program, or the SAFE Grants Program, funded with $32 million, or 67% of the $48 million South Carolina received. Under the program, approximately 5,000 one-time grants of up to $6,500 per student would subsidize the tuition for eligible families living up to 300% of the poverty level, or $78,600 for a family of 4, at participating private, parochial, or independent schools in South Carolina. However, in South Carolina, we have 180,000 of the state's most vulnerable students who live at just 100% of the federal poverty level, or $26,200. The state had said it would give money to public schools so we could safely reopen and get our kids back into the classroom. Well, the proof is in the pudding, folks, and right now that pudding is going to private schools. Diverting funds from the most vulnerable public school children to less disadvantaged families of private school students runs afoul of the board's longstanding position of opposing efforts to divert public funds to private schools. Do I have a maker?
Madam Chairman, I move the approval.
Thank you, Mr. Taylor.
I'll second the motion.
I have a maker, a motion, and a second. Dr. Royster, would the administration like to comment on this resolution?
I think he had to step out for a second.
All right. Well, I'll go ahead and since it's on the floor, I'll go ahead and open it up for discussion, questions, and clarifications, and we'll ask for his input at the end. If you have any questions, please make sure you're unmuted.
I have a question.
Yes, Mr. Sudduth.
Did the governor need approval from the Congress to make this motion that he made? The governor has said instead of giving the money to the public schools like he should, we're going to give them to the private schools.
2/3 of the money, yes, is designated.
That has to be approved by the state legislature.
No, it does not. Although, well, let me back up, Mr. Sudduth. This is being heard in the Supreme Court right now. There are arguments to be made that his efforts to create this program violate the spending power of the legislature, and those issues have not been resolved yet. But there is an argument to be made that the executive branch does not have the authority to appropriate spending.
Okay, thank you.
Anyone else? All right, hearing none, all those in favor of of adopting the resolution, please say aye and raise your hand.
Aye.
Aye.
Aye. All opposed? And the motion passes unanimously. Did Dr. Royster come back in the room?
No.
No.
Ms. Horton, is there anything that you would like to add on behalf of the administration? All right. Those are all the items on the agenda this morning.
Madam Chairman, I move we adjourn.
Second.
I have a motion and a second. All those in favor?
Aye.
Aye.
All opposed? The motion passes and we are adjourned. Thank you, ladies and gentlemen.
Good job.
Thank you for this.
Thank you.
Very nice. Thank you.
Joy, don't wear your earbuds now.